Mr. Berg, I think you are arguing for appellants. If you wish to reserve some time for rebuttal, as you know, feel free to let us know, and we'll try to honor that. 20 minutes aside. Please proceed.
Thank you, Your Honor. Please the court. Timothy Berg of Fenimore Craig, on behalf of appellant Kathy Cole Williams, I would like to reserve 5 minutes for rebuttal. And because this is a case that involves families and some people have the same or similar last names, I'm going to refer to different parties when I talk about them by their first name. I obviously don't mean any disrespect by doing that. I'm just trying to keep things as clear when I talk as I can.
We appreciate that, and we'll probably do that too, and neither do we mean any disrespect.
Your Honor, I think this case is an example of the old principle that if you ask the wrong question, you get the wrong answer. Or perhaps in this case, if you ask several wrong questions, you get several wrong answers. What the trial court did here was erroneously focus on a single point in time in evaluating both the vulnerable adult claim and the undue influence claim. And in fact, not only focused on a single point in time erroneously, but focused on the wrong point in time. What Judge Myers asked himself and then proceeded to make findings about was essentially whether Shirley had testamentary capacity on October 25th, 2007, when she restated her will through what the parties have referred to as the Marsh Will or the Marsh Amendment.
Well, certainly, as I understand it, at least, testamentary capacity was not technically an issue, but the same kinds of things, the same kind of issues and evidence, to a certain extent, would be relevant for undue influence or vulnerable adult, wouldn't it?
To a certain extent, Your Honor, but not entirely. Let me explain why I think that's true. First, I think the important thing to focus on is all the October 25th will did was restate will changes that took place in May of 2006. And when you want to evaluate whether undue influence was exerted on Shirley, you have to look at that period of time as well as October 2005. You have to really look at the whole period of time. It's an issue here which is really from, say, early 2006 through Shirley's death in 2008.
Well, the court admitted evidence, as I understand it, is of the prior periods, although as you focus on in its ruling, the court said as of this date there was no undue influence. But is the contention that there was any evidence that the court excluded going back in time?
Well, I think there are a couple of things. One, Your Honor, the court made the court you have to take the findings of the court process. And the court, Judge Myers, focused on the wrong date. He looked at first a single point in time, and I think our cases on undue influence and vulnerable adult both teach you that you don't just pick a moment or a day in time and evaluate those claims after.
Are you talking about the State of Harbor case cited on page 26 of the opening brief?
Yes, Your Honor. And that case, and as well as the Davis case. If you want to look at the vulnerable adult case, I think you need to look at the Davis case. Because Davis tells you that Judge Myers did two things wrong. One, he ignored entirely the issue of physical impairment as a way of making Shirley vulnerable. And what Davis says to you is vulnerability isn't testamentary capacity. It isn't even necessarily mental impairment. It can be physical impairment. When you have a woman who's blind, who has limited mobility, who has to live in an assisted care facility, who has other physical problems, all of which there was substantial, really unrefuted evidence of, that person can be just as vulnerable as somebody who's mentally impaired or who doesn't have testamentary capacity. The statute's intended to be a broader protection of our citizens than simply the idea of either testamentary capacity or undue influence. The reason the legislature,
I'm sorry, Mr. Berg. So what I hear you saying, though, is almost as a matter of law, if you have a person who's legally blind and unable to clean herself and whatnot, as a matter of law, she is subject to the vulnerable adult statute.
I think it's a matter, I think you obviously, all of these things are a matter of degree, Your Honor. I'm not saying to you if I came in and proved somebody had 20/40 vision instead of 20/20 vision, they're automatically impaired vulnerable adult. I think think you have to look at the totality of circumstances in any case. If you have somebody who's visually impaired, dependent on others for her care, and has other significant physical limitations. She was quite elderly and frail. All of that weighs into whether she's a vulnerable adult. And I agree that there's not a bright line test. I don't think we're going to ever say the difference between 20/40 vision and 2400 vision is where you draw the line. I think you look at the totality of her circumstances, but I think in Davis, what's clear is that this court found that where you have somebody who's physically impaired and dependent on other people as a result of that physical impairment, that person is a vulnerable adult, not just someone who doesn't have testamentary capacity, not just someone who is mentally impaired at some point. The danger of physical impairment is the degree to which the adult, the vulnerable adult, becomes dependent on other people. They're dependent on caregivers. They're dependent on family members. They're dependent, and that's the opportunity for the other party to the transaction, the person exploiting the vulnerable adult, to exploit them. If the physical impairment limits their access to other people, other things, and you have this sort of bubble created around the person as a result of their physical impairment, and somebody inside the bubble is able to take advantage of that and exploit the person. And that's every bit as violative of the statute as if I proved to you that she had no testamentary capacity. In fact, the vulnerable adult statute talks both in terms of capacity and vulnerability as alternative grounds for release. So vulnerability has to mean something other than lack of capacity.
How do we know from looking at the minute entry that, and judgment, that the court did not duly consider whether Shirley was physically unable to protect herself?
What I think you have to do, Your Honor, is two things. One, parties asked for findings of fact and conclusions of law. They submitted competing facts and conclusions of law. Judge Myers made the facts and conclusions he did. And I think you have to take him at his word. And what he did was find that she was mentally capable on October 27th, October 25th, 2007. And
We've done the same thing.
certainly, he heard a lot of evidence. He heard a lot of part of the other problem here, and I think it gives you a flavor of the case. He heard some things he shouldn't have. He didn't hear some things he should have, and that contributed to this problem.
Is there a particular...
He permitted to testify at great length about hearsay statements from other men that don't fall within any hearsay exception. And Judge Myers expressly said he was letting that testimony in because it must fit in some hearsay exception somewhere. He couldn't remember which of the 23, and because it was important. Well, I think when the judge tells you he's letting it in and he thinks it's important evidence, you can't assume he didn't rely on it.
Yeah, but could you, I understand what you're saying, but before we get off into the hearsay category of argument too much, could you come back to Judge Johnson's question? I think we're curious as to where within the findings and conclusions you would point us to support your point that he ignored physical impairment.
Well, I think if you go through there, Your Honor, there was significant evidence about physical impairment, and there's no finding in there anywhere that about the degree to about whether or not she was a vulnerable adult as a result of that physical impairment. Looking at that alone, because he didn't look at it that way. He couldn't have made that. Again, if you ask the wrong question, you get the wrong answer. If you never ask yourself, can someone be impaired as a result of physical disability, you're never going to answer that question. I don't think the court did.
You'll understand why I'm asking this. Are you arguing that Judge Myers mistakenly assessed the facts, or are you arguing that he made an error of law? Or
I'm arguing that he made an error of law. The Arizona Board of Regents case that we cited in our written brief talks about the impact on your deference to findings of fact where the judge applies the wrong legal standard. It isn't just that he misheard the evidence, it's that he, again, asked the wrong question. He didn't apply the correct legal standard. And I think that's what Judge Myers did here. I think he said to himself, the issue before me is whether Shirley had the ability to make that will, the testamentary capacity to make that will on October 25th, October 25th, 2007.
You got it.
And he didn't ask himself the right question, which is, when I look at the totality of time between 2006 and 2008 when she died, is there evidence of undue influence? Do I find undue influence? And do I find that she was a vulnerable adult? Again, I don't think you can defer to factual findings that are made under the wrong standard or that go to something that's not really an issue in the case.
May I?
Sure.
While we're on the point in sort of on the point in time argument,
Right.
On page 26 of the opening brief, there's a quote attributed to Estate of Harbor, the 1967 Arizona Supreme Court case, that we can't find in the case.
Your Honor, I don't have the case in front of me.
Okay.
Here's what I'll do. I'd be happy to go back to my office, and if it turns out we got the wrong case or it somehow was misstated, I'll put something in the record correcting that. If it turns out it's just you got the wrong page number or something, I'll put something in the record correcting that. I just don't have it.
We would appreciate it. I think you'll find it's not in the case.
Then let me figure out what the error was.
Yeah.
And say we'll file something in the record.
But moving beyond that, your point is that the judge, one of your points that I'm hearing you discuss this morning is that the judge focused too much on October 25, 07. But don't our cases and the Arizona Supreme Court cases say that that is the date of focus when that's the date of the execution of the will and trust?
First of all, not for vulnerable adult analysis. The vulnerable adult issue is really one of over some period of time was this person exploited. And it can be any time, our submission would be, it would be any time during that period. Certainly any time during that period where there's a transaction with a nexus with Arizona, where they buy the condo, where she starts paying some of the fees for the condo, where she continues to pay her daughter money while she's resident in Arizona. It isn't the point in time where the will is executed. It's at all relevant for vulnerable adult analysis. As to the undue influence issue, I believe the teachings of the Supreme Court, and we cite cases in our briefs for this proposition, you have to look at you're going to prove it by circumstantial evidence. The decedent is dead. The person who exhibited, who exercised undue influence is highly unlikely to stand up at the end of a case like Perry Mason and say, I did it, I influenced them. So what you have to look at is circumstantial evidence, and you have to look at a course of conduct over time. If you look at the undue influence cases, and you look at the vulnerable adult cases, what the courts talk about is a whole period of time within which the vulnerable or influenced persons interacted with the exploiter or influencer. And that's what Judge Myers did wrong. He didn't undertake that analysis. He didn't focus on it.
Hearsay. What specific declarations were admitted, you contend, in violation of the hearsay rule?
It is our contention that while it's permissible to put into evidence Shirley's statements about what she was thinking, all of that evidence that's hearsay from her about events that happened is impermissible. And we cite an Arizona case that draws that distinction.
Okay.
There's a distinction between my state of mind. I say, I'm happy to be here today with all these wonderful high school students, and which would be hearsay if I wasn't the one saying it. Mr. Hargrove got up here and said that's what Mr. Berg said. And my walk in, Mr. Hargrove then saying, and he told me these 10 things that made him happy about being here. One of them is a statement of my state of mind, and it's admissible. That's the first one. I'm happy to be here today. The 10 reasons, 10 factual events that made me happy isn't a declaration of my state of mind, and Mr. Hargrove testified to it. It would be impermissible hearsay.
But what specific statement or statements? What's your top 2 or 3?
It is Lori Cole's testimony about all of the things her mother said about her relationship with her sister.
The accounts of the restaurant and the fall
and the phone call, all of that sort of thing. Yes, Your Honor. And there's and what her mother told her before and after she went to visit different people. This whole case is predicated almost entirely on secondhand accounts of events that Shirley recounted to other people, and that's what the hearsay rule is intended to prevent. What it's intended to do is protect the parties, both parties, against having a case tried where the primary witness is someone who's not here and nobody can cross-examine. The purpose of the hearsay rule is to protect parties' right to cross-examination. And if I can put a witness on the stand and have them say, tell me everything John Gemmell knows about this, and they talk for 20, 30 minutes.
That wouldn't take very long.
and Judge Gemmell's not there for me to cross-examine, then I'm stuck with a problem that is, in essence, Judge Gemmell has become the witness, and I've lost my opportunity to cross-examine. That's exactly what happened here.
What about, if I may interrupt, what about the last portion of 8033 that adds, unless it relates to the validity or terms of the declarant's will?
And Your Honor, again, I think that, as we explained in our brief, if the issue here was, did Shirley sign the will? And what they wanted to do was offer a hearsay statement from Shirley saying, I signed the will, then I'm out of luck. That protects it. If they wanted to have admit a hearsay statement that there were two witnesses present at the execution and it was done in a valid way, but what it can't be, and we cite authorities for this proposition, both treatises and cases, it can't open the door to turn the decedent into the primary witness by having somebody else recite a whole series of factual events that witness supposedly was
Are you, in essence, arguing that the litany of things that others said Shirley talked about of specific events, are you in fact arguing the problem here is that those were offered for the truth of those events?
Absolutely, Your Honor.
If it wasn't offered for the truth of those events, but rather for something about her state of mind, then you would not have as much of an argument, right?
Absolutely, Your Honor. But you can tell they were offered for the truth of events, and I can see I'm running out of time, but I don't want to save a few minutes. You can tell they were offered for the truth of events by the fact that Judge Moyer made findings about all those events. If they hadn't been offered for the truth of events, why would you need to make findings?
Well, that's a good point. But what's interesting about this is that the whole issue is, why did Shirley do what she did? And the hearsay as to the state of mind, we all know, it doesn't matter whether something actually happened, it's whether the declarant thought that something happened.
But again, Your Honor, the way this case was tried, the way that was presented, the way the facts were found, they were found as if they were events. They weren't found as evidence of her state of mind.
Okay.
Again, I don't quarrel with the proposition that if someone wanted to put on testimony which said, Shirley said this about her will, that's fine. What they can't do is, I say, turn her into a fact witness when she's not available. I'm going to try to save my last 3 minutes.
Very well.
Thank you very much.
If we have time on rebuttal, we might like to hear about the recording argument, the arguments over the recording. Mr. Parker.
Thank you, Your Honor. May it please the Court, Kevin Parker for Appellee Lori Cole.
Would you come a little bit closer to that microphone, please?
Kevin Parker for Appellee Lori Cole. First point I'd like to make is the question and answer to the Court about where in the record does it suggest that Judge Myers actually considered physical disabilities. And I would cite the Court to the judge's ruling, page 5, item 3 at the bottom, which says, at no material time was Shirley unable to protect herself from abuse, neglect, or exploitation by others because of a physical or mental impairment. And that's a finding of fact, Your Honor, that I think is subject to a clearly erroneous review standard.
Although it is somewhat conclusory, wouldn't you acknowledge? We don't have the detail.
Well, I think the details are in the record in all of the medical records. I think what counsel's asking you to infer that the judge, despite admitting all of the medical records, just ignored all those. And he did. And he clearly, in the order, he also mentions the vision defect. To answer your question, I think the judge made a point to distinguish between his factual finding, which I just noted, items 3 and 4 on page 5, and his legal conclusions on the definition of the statute, which is on page 7, 15 and 16 and 17. And so I think the judge, in his own mind, and as he set it forth in his order, did distinguish between, I'm making this as a factual finding. Because of that factual finding and all these other factors, I find as a legal conclusion that she's not a vulnerable adult. One thing Your Honor also mentioned is the Harber case, H-A-R-B-E-R. we reached the same conclusion. We read the Harbor case. It's not in the Harbor case. And it's likewise, that quote, not in any Arizona case at all. We had to broaden our search. It's actually in a Georgia case, Bohlen, B-O-H-L-E-N, 509 Southeast 2nd, 628.
That's where we found it, too.
It's also notably in the dissent in the Bohlen case, Your Honor. And the majority in the Bohlen case tracks the Arizona law and specifically says undue influence must operate on the testatrix at the time of execution of her will.
Why was this not mentioned by you all in your answering brief? I can't help but ask.
Well, because I just assumed it was correct, and
Okay.
only preparing for this argument, I went to look at it, and it's like, where did this come from?
These things happen.
It was not an attempt to sandbag or sabotage. I didn't know about it. I assumed it was correct based upon the block quote and the page cite. And so it only occurred to us during the last minute preparations, Your Honor.
So I've got a question about the finding of by the trial court that Shirley was not a vulnerable adult within the meaning of the statute, and specifically the court seemed to place a significant amount of reliance on the surprising testimony by Dr. Hummels. Is that his name, Hummels?
Dr. Hummel?
Yes.
To those of us who have tried cases, I was struck by how stunned the lawyers must have been when the court effectively opened the door, invited expert testimony on this point from a witness who had not been identified as an expert witness on this point, and that there's a certain that doesn't seem fair to me. What's the answer to that?
Well, the answer is multifold, Your Honor. Having tried cases, there's a distinction between objecting when the question comes out and then waiting until you hear the answer. They waited until the answer came out, and even then they did not object. The judge, there was some discussion, and the judge asked either side if they wanted to follow up. Second, keep in mind that the judge is the fact finder on the fact, and the statute has a factual component and a legal conclusion component. A responsible judge, in my view, asks the treating physicians, well, what do you think? I have to determine this fact. What do you think? If you think yes, then I got to think about it. If you think no, well, I factor that into my thinking.
But just because it's a bench trial to the court and the judge has to make findings, I understand what you're saying, and I have the same thought process that if I was the judge, I'd want to know, and therefore I might ask. But what does that do to our disclosure and one expert rules and things like that? It kind of wreaks havoc on it, doesn't it?
Well, first off, Your Honor, the one expert rule is discretionary. That's not mandatory, certainly. Second,
but it was enforced in this case.
Fact-finding role to determine the facts and properly try the case, I think, supersedes any of that. We're trying to get to the truth here. He asks a witness who's on the stand, who knows Shirley is her treating physician in Arizona, and he asks the question. What do you think about, do you think she was unable to protect herself? Do you think she was unable to provide meaningful guidance as to her wants and needs? No, I don't think so. He treated her over the entire time she lived in Arizona. I think it's a legitimate fact question. And I don't think there's prejudice whatsoever. They had their own expert, who was the last witness, the very last witness. They make a big deal about, well, we couldn't tell our expert that the judge asked Dr. Hummel this. Well, they could ask their expert, and they did. What do you think about Dr. Hummel, in essence? He did an animal test. What do you think about that? Do you think that the treating physicians really did their job and really understood what they were doing? No, I don't think so. Well, what do you, Kathy's expert, say about the vulnerable adult? Well, I think she was a vulnerable adult. So they weren't prejudiced at all by the judge's question to Dr. Hummel.
What other expert testimony was there in the record for the proposition that she was not a vulnerable adult?
In the record, it's either Dr. Kreimer or Dr. Dottle, I don't remember which, included in their reports. She's not susceptible to undue influence, and nor is she vulnerable. We had separate expert testimony by Dr. Stephen Pitt, who said she's not a vulnerable adult. What Judge Myers did, and I think this was absolutely correct, and I think that's what any sensible person would do, is, wait a minute, Kathy filed a guardianship. We had all this done already at the time while she's alive without having to rely on post-fact, post-death experts. And so, and the judge even says that, says, I find the treating physicians more credible and more helpful than the experts, which was absolutely true. They were. They did it in real time.
What was Dr. Hummel called to the stand to testify about if he wasn't going to be asked by counsel on these conclusions?
Well, he was, as I think Your Honor alluded to, that there's some overlap between capacity, susceptibility to undue influence, all those issues. And he was a real-time treating physician that made an assessment of Shirley. And this is, his records are exhibit, I think 36, page 104 comes to mind. He has a conclusion in August of 2008, which says, essentially, this lady's amazing. She has no dementia, very stable, great lady. So we, of course, noted that and wanted to present that to the court. And by the way, we did make a very significant disclosure on Dr. Hummel. What the court required is that the parties do one-page summaries of their witnesses, and we did that. And if you look in there, it's sometime in May, June, July, before trial, where it's probably a 40-page pleading, and it has a full page on Dr. Hummel, what we disclosed. The only thing we didn't disclose, and it all deals with the medical issues, what we didn't disclose, because we didn't know the judge was going to ask, and we didn't know what he was going to say, is does she meet this criteria? So I hope I've answered the court's questions. Again, the standard in Arizona on undue influence is in the Herber case, the actual quotes from the Herber case. It is also in the Shearer case. And the Shearer says general influence is not enough. Contestant must show influence was brought directly to bear upon the testamentary act. Undue influence must operate upon the testatrix at the time of execution of her will. The Herber case actually also deals with a lot of Kathy's arguments. For example, one of Kathy's arguments is testamentary capacity is irrelevant. The Herber case says no, testamentary capacity is relevant even in an undue influence case. Here's what the Herber court says. It's page 292. Appellants at the close of their case withdrew their contentions that Mrs. Herber lacked testamentary capacity. This in itself indicates that Mrs. Herber was not susceptible to undue influence. Another of Kathy's complaints is, well, Shirley never told me about the will, and thus it was concealed. Well, Herber says there's no obligation on the part of the testatrix to publish her will to all of the world. Your Honor also noted, well, that there doesn't seem to be any evidence of Kathy's that was excluded. There was not. There was absolutely no evidence. It was just a pure speculation case, and they wanted to use collateral impeachment as a substitute. Here's what Herber says. Mere suspicion, innuendo, insinuation, and speculation are no substitute for evidence. That's what the Herber case says.
You know, as we referenced before, it seems to me the key question on both claims comes down to why did Shirley disinherit Kathy? Did she disinherit her because she was angry, resentful of her daughter, or was she unduly influenced, or did Lori do something untoward to cause that? And the court made findings, took all the evidence and made findings, but what I hear the appellant saying is that a good deal of that evidence should not have come in. The court should not have admitted it because it was hearsay, and specifically, as you heard just now, that the accounts by Lori of what Shirley told her about how she felt about Kathy. What's your answer to the hearsay issue?
Well, my answer to the hearsay issue is multifold, Your Honor, as to the statement. And by the way, this is the first time that they've actually pinpointed something they're complaining about. They just had this global hearsay. We only hear that now because Your Honor asked the question. And so what they are suggesting is that, well, after Shirley got off the phone call in December of 05 when Kathy lost it, Shirley was upset. That's what Lori's testimony was. That is offered for state of mind, absolutely admissible under 8033. But more importantly, I think for the purposes of the appellate record is Kathy admits that. In what I'd like to do, to follow on your point, Your Honor, is the court's ruling, page 2, item 7, and this addresses two issues. Number one, the hearsay issue. And number two, the suggestion that the judge restricted his thought process to what happened on that day of October 25, 2007. He absolutely did not. And if you go through 7A through F, which is what the judge says, based on the evidence, I believe this is the fair representation of Shirley's state of mind. And of course, these findings are subject to a clearly erroneous review standard. The first one is the December 2005 phone call. Kathy admits that. She admits she lost it on Shirley. That's in Kathy's testimony. We addressed that in our brief at page 17 and 18. And my point being, what Lori says Shirley felt bad about it, that's just, well, first of all, that's common sense. And we're just offering it for the state of mind. But moreover, it's an admitted fact. She admits Shirley called her and said, hey, you're using my condo. I'm not using it. Could you please pay the utilities? And Kathy lost it on her. That's Kathy's words, Your Honor. The second one is this wildfire incident where Shirley fell and hit her head and suffered a concussion. Kathy admits the event occurred. The medical records show that the event occurred. Kathy said originally that she took Shirley to the emergency room, then she admitted, well, I lied about that. I didn't really take her.
So are you basically arguing here that it didn't matter if inadmissible hearsay was admitted into the trial?
Well, I wouldn't use the word it doesn't matter. I think the judge was absolutely correct. All of the state of mind evidence is admissible under 8033. As Your Honor noted, 8033 is actually bifurcated. It has two parts. One is state of mind evidence is absolutely admissible. That's the first part. The second part, then, is the part that talks about
not including a statement of memory or belief to prove the fact remembered or believed?
Absolutely. So there's two parts to 803. It is the state of mind, which is what we offered it for, so there's no issue. There's also to prove the fact. For example, if this were a negligence case against Kathy, hey, she tripped me at the restaurant and I fell down and hit my head, Shirley's statement would not be admissible to prove that actually happened. We're only offering it to prove how Shirley felt about it. The event is undisputed. This is how Shirley felt about it. But by the way, on that same subject, if you look at part 2 of 803.3, it also says to prove the point, to prove, got my wrong page here, to prove the fact remembered or believed, that is relevant. That's where the unless clause comes in. In a will contest case, when we're talking about family relations, there's the unless clause. And so even if we were offering it to prove, which we weren't, that this incident happened, it would be admissible under this section.
But I think I heard Mr. Berg argue, and it made sense to me, that how do the specifics of specific events, the details of specific events, I should say, how do those come in under the unless clause? Because they don't relate directly, at least, to the validity or terms of the declarant's will.
Well, I think the case law interpretation of relating to the will is, why did you do this? Why are these people in and why are these people not in? And that's the Idaho case, or excuse me, I think it's Idaho. It could be Iowa. The case we cited in our brief, in the point the court says, especially in an undue influence case, where somebody's saying, you left me out because of undue influence, it is particularly important and necessary to say, no, that's not why I left you out. I left you out because of all these other things.
Although I was kind of surprised to read the cases on the other side. I think you'd have to agree the cases are mixed on that point, on how broad an exception that truly is here.
I agree, Your Honor. There is some debate in terms of how broad that is, but again, I don't think we get there. As I was going through, and I realize I'm running out of time, but the 7A through F, all of that is actual documents.
Your point is we could find other evidence in the record to support each of these findings.
Absolutely, which goes back to their strategy, which I guess makes sense strategically. They don't want to talk about anything specific because they know whatever they say, we can just say, that's in the medical record. That's an email that Kathy wrote. That's a letter that Kathy wrote. All of this is in the record, Your Honor. And on the hearsay point, the judge identifies all these things, including she demands $1.5 million, or I'm going to file a guardianship on you. I mean, that doesn't happen very often. The ultimate standard of review is, first of all, the clear abuse of discretion, which doesn't even apply because it's all admissible under 803.3. The tape, which I'm not going to have much time to talk about, is also, well, first off, it's admitted to show, as the judge noted, Shirley's mental health and mental status. She's in our interview. It's dramatic evidence of her mental state right there before she does the will. It's admissible under 803.3. It's also admissible under 807. 807 is the catch-all.
I noticed you cited that, and I wasn't sure why.
Well, because my guess was they were going to say, well, you know, even if it's cumulative and the evidence is already in the record, it's super important. It's super important, so you ought to treat it specially. Well, if it's super important, that's 807. 807 says, offers evidence of material fact, more probative on the point than which is anything else. And so point one is, everything is in the record already. Point two is, so 803, it comes in under 803 anyway, but it's either cumulative, the tape is either cumulative or it's really important. If it's cumulative, it's irrelevant. If it's really important, it goes in under 807. It also goes in under 803.3, and it also goes in because it's not even hearsay. It's admitted to show her status. I have 1 minute left. I didn't mention the vulnerable adult case. She has no standing. The judge, we asked for bifurcation. The judge said, no, we're going to try it all at once. The judge properly addressed it in order. Okay, we gave her shot. If she can turn over the will, then she has standing. She doesn't. If she wants to be a private attorney general, that just doesn't apply. The judge also found she's not a vulnerable adult, and so we don't even get to some of these other miscellaneous issues that Kathy raises. Thank you.
Thank you very much.
Very quickly, Your Honor.
Mr. Berg, I guess we've got about 3 minutes, 2 minutes?
Let's start with the finding of physical.
2.5.
Let's start with the finding of physical impairment. Again, our position is exactly what the court asked Mr. Parker about. Given the amount of evidence, given the importance of the issue of physical impairment and whether she was vulnerable, a conclusory finding like that isn't appropriate and isn't sufficient to deal with the issue. Judge Myers simply looked at this case the wrong way.
Did you, by the way, did your side in this litigation file a motion for reconsideration and argue that his findings were too conclusory and he needed to do more detail?
No, Your Honor. What we did was we submitted competing competing findings of fact and conclusions of law. And because this wasn't tried to a jury, we didn't think under statute we're obligated for a new trial for reconsideration. Mr. Parker points you to page 2 of the minute entry 7A through F. This is exactly what I'm talking about when I talk about the hearsay. Judge Myers found what Shirley intended to do based on incidents that were related by Lori from Shirley. That's exactly what our complaint is. And all of this isn't in the record. It isn't testified to by the witnesses. Or if it's testified to by the witnesses, by and large, it's somebody else saying Shirley told me this happened.
Although
Again, that's inadmissible hearsay.
We do follow the rule, though, don't we, that if it were admissible as an exception, for example, to the hearsay rule for state of mind, once it's in, even though it wasn't originally offered for the truth of the matter, now we say it can be considered on all substantive issues.
But Your Honor, you can't put in to show state of mind factual events. That's what 803 prevents. And so that's inadmissible. It isn't in for state of mind. It can't be in for any purpose. That's our argument.
I understand.
Standing. The statute provides that one of the people who can sue under the vulnerable adult statute is a child. The child asks for court permission. They get it. The procedure goes on. The judge may well have concluded we didn't make out a claim, but he can't after the fact conclude we didn't have standing when we complied with the statute. The tape. Very, very briefly. The primary problem with the tape evidence is the taping was done in violation of Illinois law. It violates a criminal and civil statute for that tape to have been done by Shirley or Lori or whoever did it without Ms. Fox's permission.
But it wouldn't violate our law.
No, Your Honor, but again, it's illegal where it was done, and the courts of Arizona certainly shouldn't take the position that we're going to give credit in an evidentiary sense to somebody who violates the law. You're sending exactly the wrong message to people if you admit evidence that was illegally obtained in the state where it was obtained. I don't think that's something the court wants to do. I see I've run out of my time. Thank you, Your Honors.
Thank you very much. Thank you, Mr. Berg and Mr. Parker, and thank you to counsel on both sides. You've done a very nice job of briefing and arguing this. We will take the matter under advisement. We will consult with Judge Portley, of course, and we will